case briefs, and so much more. LSData's got what you're looking for.
The Missouri Court of Appeals has overseen a complex case, Ramsey v. Burlington, Northern and Santa Fe Railway Company, that has evolved into a meaningful exploration of employer liability and the interpretation of the Federal Employers Liability Act, FELA. Central to the case is Thomas Ramsey, a locomotive engineer who was struck by disaster when he slipped on a patch of ice on the walkway of his locomotive engine. Despite BNSF rules demanding walkways to remain clear of slipping hazards and a protocol for using calcium chloride to melt ice, no preventive measures had been applied to Ramsey's engine. Following the accident, which resulted in a disc abnormality in his back, Ramsey sued BNSF under FELA. After a series of arduous proceedings, the jury's decision was clear, awarding Ramsey $1.4 million in an assertive statement against neglectful employer practices. However, BNSF sought to challenge this and subsequently appealed the verdict. The court has now deliberated, affirming parts of the original verdict, but also proving sympathetic to BNSF's request for an offset based on past medical expenses they had paid, which had been outlined in 45 U.S.C. Section 55. The lower court has been instructed to remove any sums Ramsey had received from his health and welfare plan from the set compensation. The decision was a relatively unanimous one, with Judges Crane and Hoff offering an agreeing voice, in particular noting that BNSF were right in denying Ramsey's future wage loss to be calculated based on after-tax income. Despite the drawn-out legal proceedings, this case serves as an important reminder of employer responsibilities and the rights of employees injured on duty.
Case briefs, and so much more. LSData's got what you're looking for. Visit lsd.law, elevate your mind. Leave the stress of climb.